Of course, if counsel wishes to deal with new matter that is not arising from cross-examination, he requires the leave of the court to do so, and this is the request that we're making in the alternative, my lord, that should this additional photos be regarded as new evidence, we request the leave of the court to canvass them with Brigadier Gininda. Then in point number 3, we deal with the reason why the evidence was not led in examination in chief. And 3.1, we point out that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination that the state was able to go through the over 700 photos of the downloads, and that a disc concerning these downloads was given to the defense some time ago. We surmise that it was in 2023, subject to correction. The state has now extracted 3 additional photos from the cell phone downloads of accused number 3 and 16 additional photos of accused number 2 that we want to show to the court. We mentioned, my lord, that accused number 2 and 3 do not dispute that their cell phones from which the downloads were made, that these cell phones belong to them. The photos belong to accused number 2 and 3 and therefore fall within their personal knowledge. And in paragraph 3.2, my lord, we make a point, as we did yesterday, that a witness can give viva voce evidence and also use photos to demonstrate his evidence as real evidence. Now, lastly, we deal with the interest of justice. In paragraph 4.1, we submit, my lord, that it is in the interest of justice to allow this evidence, as it will assist the court to adjudicate on the issues that are in dispute, and that the evidence is therefore relevant. Paragraph 4.2, we deal with the locus classicus of R versus Hepworth, 1928, AD 265, 277, that has been repeatedly referred to during these proceedings. Namely, that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other party. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. And we refer to the case of Sheikh and others, the reference is there, where the court held that the applicants stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35, 3A to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. And we also refer to the case of multi-choice and others versus the National Prosecuting Authority. And we just want to refer the court on what is stated on page 8 of our heads, where the court referred to the case of Zukuza and others, and held that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And lastly, we refer to the case of Dlamini and others. The reference is given there where Judge Krichler in the Constitutional Court described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore respectfully submit, my lord, that the state be allowed to re-examine. Sorry, there's a typing error there. to re-examine the witness on these additional photos. Well, before I sit down, I just want to mention that there's another aspect, and we just deem it appropriate maybe to bring it to the court's attention at this point so that we don't argue these matters piecemeal. There's a footage that the state is waiting for from ENCA regarding the proposition that was put by Mr. Mngomezulu to the witnesses, namely that the deceased was shot by Mr. Longwe'S, and that in the process he shot himself in the foot. There's a footage that is available, my lord, that we want to show to the court. We have started this process since December of 2024.
Thank goodness I'm not like Newsroom. Doni. I literally can go back to the record, okay, and verify it before I spew facts over here on Mzansi Unfiltered channel. Listen, I was just minding my business yesterday morning, listening to Baloyi do his heads of argument about the re-examination of Brigadier Bongani Nicholas Kininda Umshanishwa, okay, with regards to the additional 2 photos. I'm just listening, okay, giving the state a fair chance, because at the end of the day, the state does represent us. So we want to make sure that, okay, let's hear his case out. Anyway, Baloyi makes his case in Doni about why he wants the photos for accused number 2 and 3 added, whatever. It's 3 photos that he wants added from the cell phone of Umtobisi Mngube, accused number 3, and 16 photos that were added from the cell phone of accused number 2, Ubongani Ntanzi. And they found these photos, okay, because when Mnisi was going through the record of the 60,000 pages during that long adjournment, they were busy going through the 700 photos. And what stood out to me was, wait, so if there was no long adjournment, you wouldn't have the opportunity to have gone through those photos. How did you bring this case to court if you hadn't thoroughly gone through the 700 photos? To me, what it sounds like is the cross-examination was done, and then you decided to go back to the photos, the 700 photos, and go through them with a fine-tooth comb and look for photos that assist your narrative, aka building the plane while it's flying. The state has the onus to prove the accused guilty beyond reasonable doubt, not wait for the defense to give them clues to go back and look for in their own photo evidence. This to me is insane. But let's leave that one. Okay, let's leave that one. Let's get into the meat of this video, what I really want to talk about. So Baloyi then goes on to say, I also want to add, my lord, that we also have a footage that would also like to add to the exhibit that we want the court to see. This footage, we've been waiting for it from the ENCA, that shows a Longwe'S with regards to what Mngomezulu's assertions that Longwe'S shot himself in the foot. We started this process in December 2024 to obtain this footage. Ladies and gentlemen, I sat up in my chair because we know what happened in December 2024. December 2024, the 10th of December to be exact, is when Advocate Chilani Joshua Mngomezulu passed away. We also know that they then went on a long adjournment for the Christmas holidays. And then we also know that Mnisi Wemvula became the lawyer for the legal representation for accused number 1. So when did the state have time to then suddenly be searching for this footage? Do you know why I have issues with this information? Advocate Chilani Joshua Mngomezulu placed on the record of the 29th of August 2024 that, and I did a video on it titled Mngomezulu Exposes Longwe'S Gunshot Wound, Doctor's Visit, and the Secret Melrose Arch Meeting. Okay? You didn't hear me, did you? Okay, I'll say it again. It was on the 29th of August that Chilani Joshua Mngomezulu, advocate, put this on the record. So from the 29th of August, We do know, okay, that Brigadier Bongani Nicholas Gininda was running up and down the hospital searching for this evidence, okay? Didn't find it. And then only in December, only after Ngomezulu has passed away, do they now want to bring footage. Oh my goodness, guys. Oh my goodness. What a bombshell Baloyi just revealed without realizing. So it took for Advocate Ngomezulu to pass away for the state to then bring the footage. Wow. I need to sit on that. I think I need a whole weekend to sit on that, because why did they not apply for this footage in August 2024? So I'm going to count the months in between from the time Ngomezulu made those utterances. I remember because when I did that video, I was just so shocked. You should go back and watch that video. It's actually absolutely hilarious. Wow. Baloyi. Oh, how many times did I call you? So, September, you couldn't put this application with the NCA. October, you couldn't put this application with ENCA. November, you couldn't do it. You had to do it just before the Christmas holidays. Wow. And it had to be after Advocate Ngomezulu had passed away. What? Well, we don't have the date. He doesn't tell us the date. I'm just the one jumping to conclusions here. So I'm going to drop it allegedly, okay? Because I don't know when they did this application with the NCA. He just said December. He didn't say December what. Maybe that's on purpose that he didn't say that. Anyway, let's go ahead and listen to the rest of what he says. I'll definitely meet you in the comment section because I want to hear what you think.
To obtain this footage, but there's a certain procedure that is involved. There's an agreement that was entered with the South African National Editors Forum, SANEF, in terms of which the permission of the Director of Public Prosecution must first be sought before a subpoena can be issued against any journalist. We started this process in 2024, and the NDPP did give authorization, and Section 205 subpoena was issued for the footage. But there's been toing and froing with the legal representative of ENCA. But about 2 days ago, Malot, they undertook to furnish the state with the footage, and we also want to take Brigadier Gininda through that footage. It's a 2 minutes footage that will not take long, Malot, and we just want to include that, Malot, as part of the state's request to re-examine Brigadier Gininda on that footage. It wasn't specifically canvassed during cross-examination. It's a new matter, and we seek the court's permission to, as soon as it comes to hand, to re-examine Brigadier Gininda on that footage. As the court, please.
Yes, sir. Need any response?
So let me know what you think, okay, about Advocate Baloyi's bombshell regarding the ENCA footage. It is 2 minutes long. Let me know in the comment section your guess which footage that is. Obviously, this is footage that is in the public domain, but why then didn't they just play it, from the public spaces? Because they want the source material, okay? They don't want to be told this was altered. They want to see the original source material. They want the raw file. They want to zoom. They want to study it. And ENCA, in Baloyi's words, have been toing and froing. Let me tell you, that's a new expression for me, okay? They have been toing and froing. You mean just like you with the AVL records? Because you've been toing and froing. Okay, I'm digressing. Okay, let me stay on topic. The ENCA's legal representative has been toing and froing, but finally, 2 days ago, they are inside Pagati and they will be giving that footage. Oh my goodness, I definitely will start another video for the response from the defense team, because this is a developing story. Let me know your thoughts in the comment section down below. Thank you for watching. Remember to like, comment, and subscribe. Enjoy the rest of your weekend. Bye.